You get your name replaced or here? You replaced with me?
Okay, we're
No, I have to.
Oh, you had to?
No.
All right, I'd like to call this meeting of the Board of Zoning Appeals to order. If we could just say a quick invocation. Dear Lord, we thank you for this opportunity to come serve the people of Anderson, help us to make wise decisions that benefit those people. Also, want you to be with board members that cannot make it here today for health reasons or other reasons, and be with them and help in their healing. We ask these things in your name. Amen. Do we have any addenda to the agenda?
no, sir, nothing else to add tonight.
All right, everybody has a copy of the minutes from February 28th. Any additions or corrections? We have approval of the minutes. Motion to approve. Do we have a second? We have a second. All in favor say aye.
Aye.
All opposed, like sign. All right, minutes are approved. We'll go right into the hearings. First one is public hearing AA 1902, a request for a variance from front yard setback requirements at 130 Cayman Way.
The applicant is requesting a variance from front yard setback requirements for a garage addition on the property of 130 Cayman Way in the Smithbrook subdivision. Property is a single-family residence. Now, the property has an existing single-family house on it. Now, the applicant requested approval of a proposed garage addition through the Smithbrook Homeowners Association. Now, the proposal showed the garage being 25 feet from the front property line. Now, the current restrictive covenants for the development require a 25-foot front yard setback, and so the project was approved by the Homeowners Association. The applicant then applied for a building permit through the city for the project. The correct setbacks for the zoning were shown on the permit. The property is zoned R15 single family, which does require a 35-foot front yard setback. The city enforces the setback language shown in the zoning, not in the Homeowners Association guidelines, and so basically by city standards, it's 10 feet too close to the front property line. The applicant started work on the project and called for an inspection. The inspection showed the proposed footing was located 25 feet from the property line, not the required 35 feet. We did then stop work on the project pending the variance request. Now, the applicant is therefore requesting a 10-foot variance from the front yard setback requirements to allow the project to continue and be completed. Now, we have sent a letter to the person who was listed on the approval letter as the president of the Homeowners Association, informing them of the conflict between the two documents and notifying them that we would be required to enforce a 35-foot front yard setback, and essentially, please don't approve 25-foot items without the zoning approval first. In terms of findings of fact, you're familiar with those. We do find that it meets finding of fact D. Under A, we do not find that there are any extraordinary physical conditions related to this property. Clearly, it's built on. It's a relatively flat lot. It's in use. And so they do have a two-car garage on the property already. B does not apply because do not feel any particular physical issues with the property. In terms of C, the property is being effectively utilized as indicated by the existing house on the site. We did find that it met a finding of fact D, that approval would not be detrimental to the surrounding neighborhood as indicated by the Homeowners Association approval letter. However, we are recommending denial of the request due to the fact that it only meets the one of the four requirements. So with that, I'm happy to answer any questions you have for staff. The applicant is present tonight as well as another interested party. So.
Okay, any questions for staff? All right, that was going to be my question. How far along they get?
Yeah.
There's actually no, just the wall and no concrete down there, just the rebar.
Had dug up the property to allow the footing to be constructed, and so that was the first inspection that they had called for, was to make sure that that was appropriate so they could pour the footing, and so it was that point that would stop them. So.
Okay, we're going to, if you're the applicant, we can let's ask the staff questions, and we'll get the applicant a chance to talk and answer questions just a little bit. Anybody else have a question for the staff? Okay. I'm assuming one of y'all's advocate, if you'd like to come up and state your name and you can state your case if you like.
I'm Todd Munson, live at 130 Cayman Way. I'm going to give you a little history if you've got a few minutes. I understand pretty well now what the R15 zoning is, but I'll plead ignorance before all of this started. Give you a little history. I first applied through the ACC for a detached garage, and it actually would have met all of the R15 zoning requirements. It was shot down or opposed by a handful of the homeowners. And so this design ended up being the compromise. I guess both of those would have met all of the HOA guidelines, and this in fact did meet the guidelines, which I thought was gospel. The more I've learned from looking at the R15 zoning too, I didn't realize that the front pins were 25 feet in from the center line of the street, which I understand that now it does conflict with what we've done here. The HOA governing documents did not mention anything about the R15 zoning, or I would have looked at that. It also didn't mention with the 25-foot change that they had made to the setback that a variance then would be required. As you can see, construction was started. Mosteller actually got the permit for me, and this is Mosteller Construction D sitting here. So again, I honestly didn't even see the permit until it was at this phase and it was put up for the first inspection. And then I heard that things were stopped, but still a little bit unclear of why. Hindsight again, if I'd have known this from the beginning, I probably would have gotten the permit, asked for a variance, gone through this exercise and not had all this work put in. Because beyond just the footings being dug, a sidewalk was tore out, bunch of the concrete for the driveway, sprinkler system moved. So there is a lot of time and investment already here. I do need the garage space. I'd like to park my truck inside. And sidebar, last week, parked in the street, my truck was stolen. I read up on the R15 too, and part of that was the idea of having additional green space on the front of the house. It makes the neighborhoods look much nicer. One advantage with this home, there was no plan for a sidewalk. So that adds to green space. So doing this really wouldn't take away that much. Beyond that, I don't have any other argument or plea.
Okay. Does anybody have any questions for the applicant?
No, I always hate it when we have these cases, when it shows up and they've already started, well, construction like this, and then something comes up.
Well, let's, we'll have discussion amongst ourselves in a little bit. Does anybody have a question for him? Because I think we may have some other people that need to talk. So do we have any questions for the applicant? Okay, thank you.
Thank you for hearing me.
Is there anybody else that would like to speak for approval? All right, do we have anybody else that would like to speak against? All right, please come up and state your name, please.
I'm Shirley Timmons, and I've lived at Smithbrook since 2004. I am the president of the Homeowners Association currently. There's a long, long history to the covenants, our covenants. The letter that was sent to you all saying that the Homeowners Association had approved the request also includes a paragraph that the petitioner should make sure that he is in compliance with all city, county regulations, etc. That's one point of consideration. The other point is that our covenants from 1999 were changed in 2016. And in 2016, that's when the setback was arbitrarily changed from 35 to 25 feet. This is without the recognition of the homeowners. Those 2016 covenants were approved based on the 75% of the homeowners agreeing. However, the process of presenting those changes was not appropriate. They were not delineated so that the homeowners were aware that this change was occurring. This is only one change out of several changes to those 2016 covenants. Over the past 6 months, the Homeowner Association Board, and again, I have been president for 2 months. The board has agreed that we need to go back to the previous covenants because the process of changing them were not appropriate. So I say that to say we support the recommendation, the judgment from the staff of the planning board, and we want to make sure that in the future that those setbacks adhere to our standards, our original standards, the 35 feet, as well as the city standards of 35 feet.
Okay. Anybody have questions for, well, you said your last name is Timmons?
Timmons.
Okay.
Hi, Ms. Timmons.
Yes.
Why were you not made aware of the change in the restrictions?
Well, in 2016, I certainly recognized that this change, as well as several other changes, were made to those covenants. And I personally spoke with the president of the Homeowners Association at that time. However,
Aware that there had been changes.
I was aware, yes, that there had been changes, and spoke with the president at that time, but there was no change to the process.
Okay. And you're saying that the board, that, I mean, your homeowner association didn't want to approve it, but approved it because your covenant said it was okay.
That it was okay, that it was,
But you see his point though, he went to y'all by
I
your rules.
well, the petitioner is aware of the changed setback. He's aware of the changes in the overall covenants. Also, he's aware that he was to make sure that that process was compliant with the city regulations.
I agree. Anytime you get something, you're supposed to check with both, but, you know, first place I'd go is probably to the homeowners association and say, look, this go with my covenants, but, all right. And, that's, I mean, it's not really a question, but I just wonder why y'all approved it. If, I mean,
Well,
or you want denial because what he applied for was under your rules.
they were under the rules, but there is questionable how valid the 2016 covenants are,
Well,
because
that's not his, I mean, he can't, he
That-
just went by what's in place at the time.
he was aware.
Yeah.
And again, in that same letter, the second paragraph, there are only 2 paragraphs. The second paragraph specifically indicates compliance with the city guidelines.
Absolutely, absolutely. I would say you have to do both, so. Any other questions for Ms. Timmons? Thank you. Is there any discussion amongst the board? You had a,
So now,
I mean, we need to make it loud enough for everybody to hear.
So now the homeowners association is against the approval.
Right.
That's not true. She can't speak for all.
Okay, I mean, if you'd like to get back up and state rebuttal, please do.
I don't think she can speak for the entire homeowners or even the board. In fact, there's another board member here that could speak on my behalf too. I would just simply state that she's opposed, stating for herself. The only other comment that I've got too is there are other homes in our subdivision that do not meet 35-foot setback. The one right across the street from me, which is on a rectangular lot. It's not a corner lot, it's not on a cul-de-sac or the end of a cul-de-sac. That's all I have to say.
All right, thank you. All right, I'll let you have one more speak, but we're not gonna go back and we're not going back and forth on this sort of thing. All right, and I will have a question for you when you,
Okay, and I don't want to make this personal. Again, I do represent the homeowners. The homeowners were only aware of the hearing 2-3 days ago. There is an additional board member who supports the staff's recommendation. And he is in Greenville, and I have an email that he may not be able to get here, which he hasn't gotten here. But again, the process of notifying the homeowners, it's likely that more people would be here. I haven't reviewed or received the process of initiating a petition, but I say that just to say that the signage was only posted over the past 3 days. In talking with my board members over the past 5 days, after receiving the letter from you all that actually went to the board member here in support of this effort, even though he's not the president, even though he's not the person who drafted the letter that you have. The bottom line being, the homeowners are not aware of the hearing and what's going on. When I talked to the planning committee department over the past weekend, I asked for a postponement, at least until the homeowners could be aware of what's going on. And so we're here today.
okay. My question was, are you here as a representative of the homeowner association or as a concerned homeowner in the subdivision?
Both.
You are representing,
I'm the president of the homeowners association. Currently, we have 4 members. Again, the person who wrote the letter.
and you polled all 4 members?
I beg your pardon?
And you polled all 4 members and had a vote on, and made a decision, a formal decision on what homeowners agree on and disagree on, or whether to deny or approve?
Just repeat your question.
If you're representing the homeowner association, have all the vote, has everybody on the board voted on this and you're giving their vote, or
The hearing, this
on whether to,
petition,
yes,
the homeowners are not aware.
the
I'm
board
saying-
members, did you poll all the board members?
Yes, the 2 here, myself, there are only 4. The person, Mr. Blankenship, who is the author of the letter that you received. He has an email, you can see it, he's in green.
That's fine, I'm just asking if you're, what capacity you're here, as either a concerned homeowner or
Both,
representing the board?
both.
Okay, all right. Any other questions for Ms. Timmons? Okay,
The letter that she's referring to is one I wrote to them addressing the zoning versus the restricted covenants and how we would have to enforce the 35 feet versus there for 25 feet, and asking them not to approve future applications at 25 feet without a variance being done first.
Okay.
And so as to the sign, the hearing was legally advertised in the newspaper. There was some confusion, and the yellow sign that we put out was not posted until Monday. Legally, the ad is the required advertising, but we usually try to do better with that, with posting the sign on the property, but there was a miscommunication.
Okay. I mean, that's up to y'all. I don't know. I mean, we could. You want to, how long is a yellow sign usually out there?
Usually 15 days.
Yeah.
And it went out
Yeah,
Monday.
3 days. Well, I mean, we could do that. I mean,
Don't feel comfortable having this much discrepancy between
Yeah.
the people and
I
not
don't
having
either.
that much.
I don't.
okay, well, if somebody can, if you want to make that motion, we'll certainly consider it.
Make a motion that we postpone this case until next month?
Until till signage can be put out for the normal time of 15 days. Okay, do we have a second?
Second.
Okay, we have a motion and a second to postpone the decision until signage can be put out, let everybody in the neighborhood know more about it. That way they can come back and have more input. All in favor say aye.
Aye.
All opposed, like sign. Okay, this is postponed until next month. All right, we'll go into the next item, which is AA 1903, a request for variance from side yard setback requirements at 107, 109 Premier Court.
The applicant is requesting a variance from side yard setback requirements for an existing duplex located at 107 and 109 Premier Court. Now, the property is zoned RM10 multifamily. The property has an existing duplex on it. At the time of construction, the required side yard setback was 5 feet from the property line. A survey that was done recently shows that the building is actually located 4.4 feet from the property line. On that right-hand side of the duplex. This means that the structure is approximately 8 inches too close to the property line. The applicant is attempting to sell the property, and this discrepancy is holding up the sale. The new buyer would like to ensure that the building is legally located. Therefore, the applicant is asking for a variance of 8 inches to make the building location legal moving forward. This would be a variance to allow it to be at 4.4 feet for the side yard setback, a utility easement, and for any drainage easement in that location. And so we would address all 3 issues. Neighboring property is already developed. It appears that the structures are approximately 20 feet apart. If both properties met the minimum requirements, they could be as close as 10 feet apart. In terms of findings of fact, we do find that it meets findings of facts A, B, C, and D. A, the house is already built and has been in place for approximately 15 years. So this is a factor on the property that is already existing. This particular situation appears to be unique to the property. The alternate solution would be to move the entire house or to require the owner to purchase additional property from the neighbor to expand their site. D, we find this will not be detrimental to the surrounding neighborhood as an existing condition. They're not asking for any additional development, any additional density, anything like that. So we are recommending approval of the request based on these findings. I'm happy to answer any questions that you have, and the applicant is here tonight as well.
Any questions for staff?
So, Mr. Gilmore, we're talking about 8 inches.
Correct.
Okay.
And something that's been there for 15 years. I'm assuming there's been no opposition.
There is not.
Okay. Any other questions for staff? If you would, there again, if you're the applicants, I'm assuming, if you'd like to state your case, you can, and you don't have to. All right, any discussion amongst board? We have a motion to approve and a second. All in favor say aye.
Aye.
All opposed, like sign. That is approved. Okay, do we have anything else on the agenda?
No, sir.
All right, do we have a motion to adjourn? And a second?
Go ahead.
All in favor say aye. All opposed, like sign. We are adjourned.